Hi, it's Shan Wu with a Undercolor of Law analysis of Donald Trump's last effort to stop the Manhattan DA's case from going to sentencing. So the Trump legal team is now 2 for 2, or 0 for 2, but 2 for 2. They've lost both efforts. They tried to get the New York State court to postpone his sentencing, and their highest court in New York, that's the Court of Appeals. The Supreme Court's actually the trial court in New York. That state court denied his effort to stop it, which left only the United States Supreme Court. I believe that there wouldn't have been time for any of these things if Judge Merchan had just sentenced him in the summertime. But we were waiting on the United States Supreme Court. They have now acted, and they denied his request for an emergency stay. And now we will be going to sentencing. Now, the stay was an order, so it's not a full-blown hearing with an opinion or anything like that. And it's very short, but certainly worth breaking down. So let's put it up for you to take a look at while I talk about it. So it was originally presented to Justice Sotomayor, who referred it to the full court because it was an important case. And what they found was they denied his request based on 2 reasons. The first was they said that most of his arguments can be addressed in the ordinary course of appeal. And then secondly, they said that the burden that this sentencing will impose on the president-elect's responsibilities is relatively insubstantial in light of the trial court stating that it's going to impose a sentence of unconditional discharge after the brief virtual hearing. So a couple of things here. First of all, number one is what people, including me, have been saying for a while, is that everything Trump's complaining about with regard to the evidence being admitted, his argument is that Merchan, who had agonized over this, had misapplied, had violated the Supreme Court's immunity doctrine because at the time of the trial, when that doctrine didn't exist yet, Merchan had allowed in evidence, some of which was testimony or things that happened when Trump actually was in office, like maybe had a couple conversations all in the Oval Office about the case, about the cover-up. And so Trump's lawyers wanted to say, hey, that was evidence which should never have come in. It really affected the jury verdict, yada, yada. That's exactly the kind of thing that you take up on appeal. So think about that from other kinds of more, matter-of-fact criminal law cases. You want to argue that they overstepped their bounds here. This evidence was irrelevant, was too prejudicial, etc. That's what the appeal is for, rather than having all of this hullabaloo before you can even get to the sentencing, before you can even get to the appeal, to have to sort all that out. So the Supreme Court recognizes that all those arguments being made are appropriate for appellate resolution, not in this weird sort of pre-sentencing mode. Of course, we wouldn't even be in this situation if Chief Justice Roberts had not basically invented the presidential immunity doctrine out of thin air. But like I said before, many people recognize in a normal criminal case, that's exactly the kind of thing that gets taken care of on appeal. So that's what's going to happen now as to those evidentiary issues. Now, the second reason I think is actually a little bit funny. The majority here is saying kind of, who cares? Nothing's going to happen anyway. And maybe we should give Merchan some credit for finding a way out of this kind of like trap that he partially built himself. I've been critical of Merchan for saying he's going to do this unconditional discharge, which basically means nothing's going to happen to Trump. He'll have the conviction, no community service, no fine, certainly no jail time. But maybe Merchan was clever about this, because by letting everybody know that, hey, my sentencing doesn't matter because nothing's going to happen to the guy, why not let it go forward? And the majority of the Supreme Court said the burden of this sentence is, quote, relatively insubstantial. I mean, I'll say all he's got to do is get on a little Zoom call from Mar-a-Lago that morning, maybe a little bit earlier than he normally would want to get up. Then he's done for the day. Now, what is interesting here is the vote breakdown. Chief Justice Roberts and Justice Amy Coney Barrett broke from the extreme right regime of Alito, Thomas, Gorsuch, and Kavanaugh, and they actually voted with the liberal wing to deny the stay. Now, remember, the stay's basis has got to show this irreparable harm, and of course they can't show irreparable harm because where is it, right? I mean, he hasn't been sentenced yet, he's not going to jail, and any harm that comes from an error in a criminal case, from the conviction, gets remedied by the appeal. So it's an interesting breakdown there, and let's talk about that a little bit. I would say that in the coming years, watch for Justice Coney Barrett to be the occasional fly in the ointment for the MAGA right, at least until Trump can manage to get a super majority by getting Judge Eileen Cannon on the SCOTUS bench. Just kidding, but not really. He would love to have that happen. Now, Chief Justice Roberts also joined Amy Coney Barrett in voting against granting Trump the stay because, frankly, who knows? Maybe there'll be a lot of speculation you'll hear in mainstream media that Roberts was very conscious, concerned about the court's prestige and its standing in the public opinion. I mean, could it sink any lower than he's already brought it down to? Maybe actually thought Trump had not met the legal standard. Wow. It's very hard to know. It's all speculation. Frankly, his legal analysis seems to have sailed and is not coming back. I would say the high court's quick rejection helped lay some foundation here. And notice that the extreme right on the Supreme Court would happily have overridden the will of the people in the state of New York. It's a criminal case. It's their laws that were broken because they don't care. The majority there feels completely enabled to believe and act as though only their thinking matters, their point of view. It's not really legal analysis. That's just unchecked power. And of course, the real important part of the scandal in the vote breakdown is that Justice Alito even participated. So at this point, we've heard the story about Alito and Trump having a phone call. This phone call, we'll put up the headline in case you missed it. This phone call happens only hours before Trump files this emergency petition. And his phone call, Alito's phone call, is only the latest in the mountain of reasons he should be recused from all things Trump, running up the flagpole with the flags at his house that support the election deniers. I mean, hell, there's an argument that Alito should be recused from anything that the Trump DOJ brings. Of course, that would be the majority of the court's docket. But of course, he won't do that. And we need to examine just how outrageous is his behavior in the context of the legal and ethical standards. So he takes a call from Trump hours before Trump files this emergency stay petition. And supposedly the call is just about Trump wanting to discuss Alito's former law clerk getting a job in the Trump administration. Really? The President of the United States is calling a justice to discuss this application all of a sudden? I mean, how often is that going to happen? It's not that there's something technically wrong with the justice wanting to give a personal reference for his former clerk, but it's the timing and the highly unusual situation of the president actually reaching down for that reference personally. That's just not the way things happen, and darn lucky timing for Trump, huh? So Alito, of course, claims, and maybe he's telling the truth, they did not discuss the pending petition. And honestly, why would they need to discuss the pending petition? The whole point is that Trump's making contact with Alito. And Alito claims that he didn't even know it had been filed, or he was really surprised when it was filed. That kind of thing just adds fuel to the fire. I mean, isn't it truly amazing what Justice Alito is unaware of? I mean, he's unaware of this case everyone's talking about. Will Trump go to the Supreme Court? Everyone thinks he will. He's unaware that that's going to happen. He's surprised by it. He's unaware that his wife has been running up flags at his houses. I mean, even the justice's own very watered down, convoluted ethics code, quote unquote, must be twisting in agony. I mean, look at the standard here. We'll put it up for you. The specific part that's particularly relevant here would be their Canon 3B2. And it talks about when a justice should be disqualified. They're presumed to be impartial and they have an obligation to sit, unless the justice's impartiality might reasonably be questioned. That is what we usually refer to as the appearance of impropriety standard. And what's important about that is it's a standard. I mean, it's not just some feeling that people have and the justice says, well, I don't have that feeling. It's a standard. The standard is the appearance of impropriety. What looks like it could be an impropriety here? The fact that his house runs up flags associated with the MAGA movement? The fact that he's talking to the president, president-elect, only hours before the president-elect files his petition asking the court to do something? Of course, if he was looking to abide by the appearance of impropriety, this looks incredibly bad in terms of the appearances. You'll hear mainstream media, everyone will be talking about how, oh, the optics of this are terrible, the optics of this are terrible, as though there's a different standard, right? There's the optics, and then there's the ethical or legal standard. Those are the same thing here. This is the optical standard. It's the appearance of impropriety. So he's clearly violating that. Let's look at a now ancient incident a long time ago in which Attorney General Loretta Lynch spoke with President Clinton on the tarmac of an airport. Both planes were there. And they talked, and it was during this investigation of Hillary Clinton's emails. It was still floating around at that point. This apparently caused so much concern, so much outrage on the part of then FBI Director Comey. I mean, take it with a little bit of grain of salt how he describes this in hindsight. But according to Comey, testified under oath to Congress about this, Comey felt he had lost confidence in the DOJ leadership to have any integrity because of that one conversation. That meeting is what caused Comey to supposedly announce he was reopening the Hillary email investigation just before the election that she lost to Trump. I bring that up because it is an example of how much outrage was expressed over a far more innocuous meeting, certainly in terms of the timing. And the fallout from that outrage caused Attorney General Lynch to abdicate her responsibility. She basically recused herself from leading that investigation, recused top DOJ leadership from running it, and she delegated to Comey and the FBI officials. The rest is history, right? Comey announces to the world he's reopening this investigation for whatever his reasons were. And obviously that very likely, or certainly potentially, had a huge effect on that election. That's not uncommon. I had worked on matters with Attorney General Reno where, for various reasons, the Attorney General felt that she should be recused from it. That's basically what AG Lynch did. And she was doing, you can hindsight 2020, you can question why she did that, but she did that because she was concerned about the appearance of impropriety, much the same way that Comey rather dramatically is saying he lost integrity, his faith in the integrity of the DOJ leadership. That error by Clinton and AG Lynch, mild error, maybe talking when they shouldn't have talked because they both happened to be on the airplane tarmac in their planes, had the butterfly effect, right? Caused maybe the election to go to Trump, and it gets us to where we are today, where Trump is coming into a second term. The justices don't even pretend to having concerns about being held accountable for the appearance of impropriety standard. Trump being sentenced isn't going to change any of that, but it's the right thing to have happen. Maybe the only right thing that has happened in any of the criminal justice system's treatment of Trump. So let's not lose sight of that. It's hard to celebrate such a small normalcy, but it would be wrong to ignore it. DA Alvin Bragg, his prosecution team, and Judge Marchand got this much right. They brought this case home. It's going to be sentenced. It's going to be concluded. There will be a conviction. And to that extent, they got it much more right than anybody else has. So that's it for now. Good to see you. Good to talk to you again. And keep those replies and comments coming. We really appreciate them. And we'll talk to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.